Honourable Judge, distinguished guests, fellow colleagues and students of law, it's my pleasure to welcome you this evening to our Yong Lin Professorial Lecture. To do the introductions at this stage, I simply invite the Dean, Professor Sinister, to the podium.
Justice Kimurasamy, distinguished guests, ladies and gentlemen. Good evening. In 2002, NUS established the Yong Lin Professorship in Intellectual Property Law. It did so to honour a pioneer of the profession. Mr. Yong Lin was the first ethnically Chinese person to be called to the bar of the Federated Malay States. He was a brilliant, Cambridge-trained lawyer with a strong social conscience. His practice, Messrs. Yong Lin, now Lin & Bok, was set up in Malaysia back in 1918. It is one of Malaysia's oldest law firms. And Mr. Yong's son, the late Yong Bung Hao, was also educated at Cambridge. He too became a partner of Lin & Bok. As we know, however, he subsequently left the practice of law for his own distinguished career, first in banking and later as the second Chief Justice of Singapore between 1990 and 2006. This professorship, to honour his father, was established by a gift from Chief Justice Yong and his wife, who sadly also passed away just last year. We are deeply grateful to Mr. and Mrs. Yong for their generosity. Now, many people don't realise this, but even though NUS benefits from very strong government funding, we teach our undergraduates at a loss. To enable us to do more, to enhance our programs and offerings, we do need additional support. And today's lecture is a fine example of the impact of such support. Thanks to the kindness of Chief Justice and Mrs. Yong, the Yong Lin Professorship has enabled NUS Law to bring to Singapore a number of eminent academics in the field of intellectual property and to increase the range and variety of our IP-related subjects that we can offer for the benefit of our students. Our latest visiting professor is, of course, with us tonight. The chair of this evening's discussion, Professor Christian Whitting, will introduce our speaker in a moment. But let me first take this opportunity to say what a pleasure it is to have Professor Andrea Stazi here this evening to speak on GMOs, human rights, and patents. Professor Stazi is a professor of comparative law and biotechnology law at San Raffaele University of Rome. He's also one of us, inasmuch he's an academic fellow of our Centre for Technology, Robotics, Artificial Intelligence, and the Law, or, as Singapore's many acronym lovers like to call it, TRAIL. Andrea, thank you for coming once again to Singapore, and I'm very much looking forward to hearing your lecture. And finally, let me close by saying welcome to all our audience. I know that we're all looking forward to hearing from Professor Stazi, and to that end, I would like now to invite my colleague, Professor Christian Whitting, to introduce our speaker. Thank you.
And thank you very much, Dean Sinister. It is indeed my pleasure as well to welcome our distinguished guest, Professor Andrea Stazi, to this lecture hall tonight. And I'll provide you a little bit of a background on our visiting professor. So he is a professor of comparative law and biotechnology law, as has been mentioned, at San Raffaele University of Rome. And most recently, he was also professor of comparative law, intellectual property, and new technologies law, policy and management at the European University of Rome. Obviously, he is now the Yong visiting professor of law here at NUS and teaching the course Biotechnology Law. Professor Stazi is author or editor of many works touching upon areas of critical importance for us. Just to name a couple of these works, they include the books Smart Contracts and Comparative Law, as well as Biotechnological Inventions and Patentability of Life. He has an habilitation in comparative law and also in commercial law. He is a PhD graduate in competition law. At this point, I would like to pay tribute to and reflect upon the remarkable nature of the expertise that we find in Professor Stazi's work. His work involves, in my opinion, deep insights into science, technology, international law, comparative law, and intellectual property law. And this is no small feat. It entails a huge investment in researching and exploring well beyond a single discipline in a way that really is becoming more and more difficult in a high-pressure academic world in which productivity and quick results always seem to be important. Yet the complexification of everything in this life requires exactly the sort of time and dedication to learning that new problems bring us. In Professor Stazi's case, we're talking about new problems at the interface of the worlds of law, technology, and science. It is also important to us as an institution, to Singapore as a country, that Professor Stazi has been willing to come to Singapore, to NUS, in order to engage with us in dialogue and debate so that collaboration can occur, we can learn from each other, and that a base can be created for what we will see is needed here, international cooperation in resolving very important, indeed urgent disputes. As I say, I would pay homage to Professor Stazi for the breadth of his investment in his own learning and understanding and his willingness to come here and share some of the results with us. As mentioned already, this evening, Professor Stazi will present his paper on GMOs, human rights, and patents. And at this stage, I welcome him to the podium. Thank you.
Good afternoon. Thank you, Professor Simester. Thank you, Professor Whiting. And I'm honored to be here with you today. Under the name of such a great lawyer, a civil servant, to provide some outcome from my studies about biotechnology law, with particular reference to the latest studies I've been doing about genetically modified organisms that are probably the most complex issue within the realm of biotechnology, given the number of issues they create and their interplay with, in particular, with human rights and with intellectual property. So, without further delay, to fully respect your time and attention, let me move to the content of this presentation, because I try to say as many things as possible in the time we have today. So, first of all, as you may know, genetically modified organisms are organisms whose genetic material has been modified in an artificial way. Why? For basically the purpose to increase their usefulness and their value by introducing new genetic traits into food, plants, animals, as usual in the realm of biotechnology. for the sake of improving human life or health. The most common genetically modified organisms currently are genetically modified crops. And the main reason for their development is to improve their yield through the introduction of genetic traits that allow greater resistance to plant diseases, herbicides, weather, floods, and so on and so forth. In general, genetically modified organisms prefigure very interesting prospects and opportunities for various social and economic issues. With, in particular, their relevance is key potentially to help solve some key social problems, such as, for example, hunger or malnutrition. And in this way, they can be very helpful to the pursuit of the United Nations Sustainable Development Goals that are basically the main instrument, the main legal instrument at international level for human rights in action. However, at the same time, GMOs as biotechnology in general, but possibly even in a more complex way, pose various relevant issues and policy and legal problems. This is even more relevant for developing countries, for example, with regard to the impact of GMOs on biodiversity of the ecosystem, or on the survival of the local production and local farmers in particular. So, let's start from the general framework. The regulation of GMOs lies within a framework of multiple principles and interests at stake. Looking at food, for the sake of time, and because, as I mentioned, this is currently the main application for GMOs, various interests at stake here are the fight against hunger and malnutrition, and so the relevance of GMOs for human rights. We will deep diving into that in a while. Food security, that's closely related to that. But at the same time, we have other key principles and interests that are relevant in this perspective. And so we have food healthiness, that's at the center of the debate at international level regarding GMOs, with consumer awareness that is increasing in many countries. Recently, in the United States, approved and then implemented legislation regarding the transparency for GMO, as I'm gonna detailing later. As I also mentioned, we have another key interest and principle at stake, that is the sustainable development, the impact of GMOs on the environment and on both the local production and also on the biodiversity. The potential contamination of GMO crops, for example, on natural crops is a key issue to be faced. And then in the debate about usefulness or not of GMOs and the risks, we have the debate between food security on one hand, so their usefulness in that perspective, and the social movements that defend food sovereignty, saying that the GMOs are risky for reasons that I'm gonna say in a while. So, to conclude this introduction, the main issues here regarding GMOs are basically to establish first the forms and the limits of the freedom of access and the commercial exploitation of crops and genetically modified products. So the dangerous relationship between the freedom of access to genetic resources on one hand, and on the other, the commercial exploitation of GM products that are so useful potentially for many reasons, is very hard to manage. And in this perspective, intellectual property is absolutely key, because on one hand, it is the main incentive for biotech research and development, and so including GMOs. But at the same time, the balance of interest is exactly the key complex issue to be managed in the intellectual property realm regarding GMOs. Then we have the other important issue, that is regarding the protection of the healthiness of food, and related to that, the third one, that is the guarantee of transparency for consumers. So there is an ongoing debate regarding the healthiness of the GMOs. I'm going to talk about that in a while. But in any case, there is a growing consensus that consumers should be aware of what they are eating. If the food or the products that they are consuming are GMOs or come from GMO crops and so on. So, what's the relationship between GMOs and human rights? And so, a way to look at this issue is analyzing the interplay between GMOs and the Sustainable Development Goals of the United Nations that, as I mentioned, can be defined as the main international instruments for human rights in action. The goals, the 17 goals set by the United Nations in 2015 to be pursued by 2030. So the relevance of GMOs for Sustainable Development Goals is huge. It concerns most of the 17 goals set by the United Nations. I'm just mentioning them for the sake of time. So the first goal is exactly to end poverty in all its form everywhere. And in this perspective, the utilization of biotechnology techniques lead to higher productivity at lower costs. And in particular for crops, their resilience for GM crops, their resilience to climate change can promote greater prosperity in terms of more stable income for the farmers and low-cost food supply in general. Then we'll see the risk for the local small farmers. Second goal, again, crystal clear, end hunger and achieve food security and improve nutrition and promote sustainable agriculture. The production of more productive crops and more resistant crops can be and is being actually a major step forward, especially for developing countries, to increase the production of food. Third, the third goal is ensuring healthy lives and promoting well-being. Unfortunately, we have already experienced with COVID-19 how much biotechnologies can contribute in reducing the spread of infectious diseases and contain epidemics or pandemics. The same goes for Goal 6, also here. And the goal is to ensure availability and sustainable management of water and sanitation for everyone. And here as well, biotechnology through bacteria, plants, possibly genetically modified, can purify water and remove chemical contaminants. Same for energy. Also here, the bioeconomy, so the transformation from a fossil-based to a renewable-based economy, contribute to societal goals such as mitigating climate change, lowering resource use, increasing food security, and fostering economic growth, etc. Same goes for the 8th Sustainable Development Goal. So also here, the goal to get to a sustainable economic growth and decent work for all can be achieved through the relevant help of biotech for agriculture, having more resilient crops, that help farmers to make a better income, and also making the workforce healthier through biological pharmaceuticals can help in that perspective. Ninth, again, building resilient infrastructure and help an inclusive and sustainable industrialization as well can be fostered by the use of biotech research. And this is particularly relevant through the partnership that are being a key characteristic of the biotech industry at international level. We have already seen that, for example, during the pandemic for the production of vaccines. Climate change, climate action, for sure, biotech and in particular, in this case, the use of genetically modified crops capable of coping with the effects of climate change can be a key instrument in that perspective. 14, again, biotech can be key also to achieve the goal to conserve and sustainably use the life below the water, oceans, seas, etc. There are many ways to do that. For example, through genomics and recombinant DNA, new food production methods aimed at addressing the problem of overfishing are being developed. But this is just an example. 15 goal, again, protect, restore, and promote the sustainable use of the terrestrial ecosystem. So sustainability for forest, combat the desertification, and so on. Here, GM crops can allow farmers to apply conservation tillage while conserving water and soil, keep pests under control, and have crops resistant in that perspective. And also to preserve biodiversity and reduce deforestation. As I mentioned, also the opposite may be true if patents go too far and allow multinationals, for example, to exploit small farmers, but this is next in this presentation, so I will talk about that later. And finally, last but not least, we have the goal 17, that is the strengthening global partnership for sustainable development. And here, again, a multi-stakeholder approach can help to make biotech innovation accessible to everyone and to fully exploit in an inclusive way its benefits. This is very hard to be achieved, and this is probably the most difficult one because the interests at stake are so high that there is a huge debate about that, the role of IPRs and the exploitation of less developed countries through biotech by the more developed ones. But we'll talk about that in a while. So next about human rights. The key debate here, looking at food and crops, is about food security versus food sovereignty. In the world, there are about 815 million people suffering from chronic hunger and about 52 million children suffering from acute malnutrition. Considering that since decades, for example, President Roosevelt back in 1941 State of the Union speech mentioned the freedom from want among 4 essential freedoms for global security. So the right to food, basically, since then was key in the international protection of human rights. And so it was included into the Atlantic Charter and influenced the Universal Declaration of Human Rights of 1948, which laid the groundwork for 2 conventions of 1966 that specified more detailed protection mechanism They are the very well-known International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. And these documents are the basis, basically, for the activities of the International Court of Justice and the international protection of human rights. Since then, we have assisted to a wide debate regarding to the need for, to feed the world. Even more recently, after the devastating global food crisis of 2007-2008, and therefore the debate focused on the various factors that are contributing to that issue, including conflicts, wars, as we are still seeing, unfortunately, globalization and financialization of the food system, climate change, etc. And so the key question on how to feed the world is the center of the attention at the international level. And therefore, currently, and this is the food security principle that lays the ground of most of the provisions regarding food in international and regional instruments, legal instruments. Currently, the dominant view is to exploit, to develop greater and better food production and access to that through the exploitation of the existing technologies, including the biotechnology and GMOs. On the other hand, this approach has been questioned by the other movement, that is the food sovereignty discourse, that is defended by social movements. For example, La Via Campesina is the most famous, and they point out the risks of technologies, theoretically positive, good for food, but on the other hand, the risk that new technologies can bring to biodiversity, intergenerational equity. For example, the genetically modified crops can contaminate natural crops quite easily. And so they state that these can modify forever the nature and the agricultural crops around us, and not only now, but for future generations. The risk of playing God, that is the main ethical issue behind the moral debates in biotechnology. Resistance and dismantling of the industrial domain of food production and trade. Right to decision-making regarding land use and food production. Local farmers are more and more in the hand of multinationals, which hold patents on key seeds and crops, and so they are more and more able to decide how land is used and which food can be produced. And then the equality and development of the right of the peasant, of the local farmers, because traditionally, and I anticipate here what I'm gonna say, traditionally the farmers were able to spare the seeds for the next year and to reuse the seeds to cultivate their land. But more recently, since when GMOs came on stage and the multinationals have been patenting the seeds, the modified seeds, they are able to produce seeds that are not usable anymore 1 year later. And so the farmers have to buy year after year, every year, the seeds from the multinationals, obviously, with a huge loss of income. And so the movement for food sovereignty highlights that their points are provided in the peasants' rights to seeds that have been recognized in Article 9 of the International Treaty on Plant Genetic Resources for Food and Agriculture of 2004, and in Article 19 of the United Nations Declaration of the Rights of Peasants and Other Persons Working in Rural Areas of 2018. There are others that try to find a balance in this debate, in this dichotomy between food sovereignty and food security, trying to find a third way between the two. In any case, as for the legal process, in practice, in recent years, the food governance system evolved in a multi-stakeholder approach that's based on public and non-public actors with multiple regulatory models at comparative low level. There are different layers from the international level to regional and to the national government level, and there are, as I mentioned, both public and private governance levels. At international level, so the natural venue theoretically to find a shared solution, there were attempts to balance these issues and these different interests at stake, especially with the Treaty on Plant Genetic Resources of 2001, effective since 2004, and with the Nagoya Protocol of 2010, effective in 2014. Both aimed at mitigating the tensions that I mentioned, basically between the access to genetic resources on one hand and the fair sharing of benefits deriving from their use on the other hand. How the treaty, through the recognition of the contribution of the farmers to the conservation of the crops, setting a global system that allows farmers and researchers to access the plant genetic material and ensuring, providing at least, that the benefits of plant improvement and the use of biotechnology are shared between the country of origin, where the crops are cultivated, and the owner of the patent. The protocol, again, pursues equitable sharing of the benefits, specifying that this includes adequate access to genetic resources and transfer of technologies. So technology shouldn't be in the hand of the multinationals, but should be shared with the local industries and farmers, and ensuring the conservation of biological diversity. This, in theory, would be an international framework that could balance the different positions between food security and food sovereignty, but unfortunately, in practice, the treaties haven't so far given the expected results because of two main issues from the policy and legal standpoint that are, first, the non-accession, the absence of key signatories, China, Russia, US, Japan, and other very important countries. And the second is that the treaties only provide the public law international framework without getting into the contracts. So the application of the benefit sharing commitments in the contracts is left to the suppliers and users agreements. It's self-evident that the imbalance of power between the multinational and the local farmers is so high that this is not working in practice because the multinationals are too powerful to impose basically their conditions. And finally, synthetic biology is advancing so much that now genetic material can be increasingly extracted, processed, and exchanged separately from the physical exchange of the plant genetic material, so that this also poses a technical challenge to the functioning of those provisions that, by the way, are not being really effective for the policy and legal reasons that I just mentioned. In this scenario, that would be relevant for all the biotechnological products, the issue of genetically modified organisms is absolutely key because, as I mentioned, they are mainly applied in agriculture, mainly applied in crops, and so in the production of genetically modified food. and so they are basically in the middle of this debate about food security, sustainability, and climate change. Another issue that they pose on top of them is the risks, as pointed out by the WHO, the risks of the involuntary introduction of allergens into food and the transfer of antibiotic-resistant genes and the migration of genes from GM plants into conventional crops. So the contamination risks. And therefore, the heated debate that originates from all these issues is ongoing between the supporters that highlight the usefulness for food security and the critics that stress all the risks that I briefly mentioned for biodiversity, sovereignty, healthiness, and integrity of food because of the contamination. So, what's happening from the legal standpoint? In 2015, the US Food and Drug Administration for the first time approved a genetically modified animal for commercial food production. That was a genetically modified salmon, which grows twice as fast as the natural Atlantic salmon. Another example, quite controversial, of GM food is the so-called golden rice, a variety which contains beta-carotene that's necessary for the synthesis of the vitamin A. But NGOs, from the food sovereignty standpoint, like Greenpeace, have criticized the production of golden rice and saying that basically the deficiency of vitamin A should be faced with conventional means, and are suing all around the world with betting on this kind of GM food, in particular golden rice. And the latest example of this case law is a recent decision of the Court of Appeals of the Philippines, which revoked the permit to plant for commerce the Malusog rice. That's a golden rice variety that was part of a plan of the state to have the variety comprise 10% of the nation's rice harvest within 8 years to meet the vitamin A deficient households. And the recent decision of the Court of Appeals basically stops that plan on the basis of the precautionary principle, stating that until scientists reach a consensus about the safety, the golden rice shouldn't be cultivated and then commercialized. At international level, the most well-reputed health organizations, starting from the WHO, the World Health Organization, the American Medical Association, the US National Academy of Sciences, the British Royal Society, etc., all of them stated that consuming foods containing ingredients derived from GM crops is no riskier than consuming the same foods containing ingredients from crop plants modified by conventional improvement techniques. However, given the debate that I just mentioned, the regulatory approach around the world are quite different, also considering the unsuccessful attempts to summarize and to find common solution at international level. The US is the world's largest producer of GM crops, and on the contrary, many countries, especially within the EU, such as France and Italy, for example, have banned their cultivation, with related global trade problems, obviously. Comparative law level, we can distinguish between two macro models that are, on one hand, the one based on the precautionary principle. If we don't know the consequences, we should stop cultivating and commercializing GM products. And this model is adopted in Europe, for example, in China, Japan, or Africa. And there is another model, that is the United States one, basically, in which a liberal policy prevails in this respect. Regarding consumer awareness about the GM issues, Europe, China, and Japan can be included in the first group, where the consumer has been interested for years, and so there are legal provisions regarding transparency for consumers. While on the other hand, in the United States, only since few years, these considerations came to the attention of consumers. So now, very briefly, I mention the regulation of GMOs in comparative law, looking at the United States, Europe, China, and Singapore, to point out the path they are following. In the United States, the first GMO patent was recognized in 1980, Diamond versus Chakrabarty case. Anything under the sun made by man can be patented, even if this is not that's true, as Professor Elizabeth Siu-Kwan wrote, because we could better say that not anything under the sun made by man is patentable, considering the exception for morality reasons that are provided all over the world, starting from the TRIPS in many countries. By the way, in 1982, the Food and Drug Administration approved the first genetically modified drug, a biosynthetic human insulin produced through DNA technology. And afterwards, the main US institutions published reports and guidelines to stress that no specific rules were provided for GM food, and as well no special labeling was required. In 1994, then, the first genetically modified product, known as flower sap tomato, was approved by the Food and Drug Administration and marketed. And again, in 2015, the Food and Drug Administration said that commercialization of GM food didn't require special labeling. So, for many years, GMOs have been commercialized in the US without any specific labeling, until some states moved forward, and then at federal level there was an action, and the consumers became more and more aware of the issue. And so, since 2016, there was a process to get to a legislation regarding labeling. Finally, the labeling was provided as mandatory, but leaving to the producers to choose the method for that. Since January 2022, the legislation is in force. In the European Union, the legislation on GMOs started since the 90s with some directive, always based on the precautionary principle. Since the very beginning, also provided labeling requirements and a specific process for GM food traceability, labeling, and a specific approval procedure for cultivation and commercialization. Legal provisions in Europe are the regulations 1829 and 1830 of 2003, that provide the current legal framework on the precautionary principle and food traceability and labeling, and the Directive 2001/18, that is important for two reasons. One is the procedure with environmental risk assessment, consent to release information to the public, labeling and packaging that it explicitly provides. But at the same time, also the freedom left to the member states to decide whether or not approve the cultivation of GMOs in their countries. And the other key provision that I want to stress is in the regulation that I mentioned earlier, 1829 of 2003, which established standards for the labeling of GMO products, requiring mandatory labeling with a tolerance threshold of 0.9 for the accidental and technically unavoidable presence of GMOs in food. Below that threshold, it's possible not to label the product as GMOs. In China, China is the first importer of GM crops worldwide. The Chinese model of regulation is based on the full consideration of the multiple risks deriving from crops, GM crops, basically. There are various legislation regarding agri-food safety of GM products, from regulations on agro-GMO biosafety management of 2001 to the licensing measures on livestock genetic materials of 2010. And these legislations impose basic rules on approval and classification of products, on labeling, and on production license. And there are further rules specifically on safety and transparency for consumers of GM food, including, as I mentioned, the food labeling. So a model that is as well based on the principle of precaution, on transparency, and on labeling for consumers. At the same time, there are several institutions aimed at controlling the production and distribution of GMOs. While in Europe, there is the European Food Agency, so basically one at the European level. In China, there is, from the legal process standpoint, there are various institutions in charge. And these brought to some criticism, saying that the rules are too strict on one hand, because the threshold of tolerance is not 0.9 like in Europe, but is 0 for GMOs. And so the accidental contamination is not considered. And there are various authorities in charge, so the enforcement is more difficult in that perspective. What about Singapore? In Singapore, plant biotechnology product development is currently minimal, and has been limited to one project to date. There is no commercial production of genetically engineered plants and no export of any genetically engineered crops. The imports of genetically engineered agricultural products in bulk form are negligible, but the country is a large importer of processed food products, $11 billion in 2023, many of which may have been derived from genetically engineered crops. What about the authorities in charge? What about the legal process? The Singapore Food Agency, the SFA, manages food security and food safety matters and regulates genetically engineered crop market access, but it makes that considering the recommendations and the analysis from the Genetic Modification Advisory Committee. That is key in the analysis of the case and in providing an opinion to the food agency. The GMOs derived or presenting similar characteristics with agents that are mentioned in the Biological Agents and Toxins Act shall be regulated by the Ministry of Health. And basically this means that the controls that are applicable to the agents listed in that legislation, that are basically bacteria, fungi, and viruses, and again, any other biological agent that causes death, disease, or biological malfunction in a human, must be regulated by the Ministry of Health. That means basically the same will happen for the GMOs, that as well these kind of agents, so bacteria, etc., can produce these kind of consequences. And what's the legal process here? The approval for possession or use may apply if the biorisk is enhanced by genetic modification. And how can developers ascertain this fact, basically? So how can developers who want to commercialize genetically engineered products get the approval? They must submit a proposal to the Genetic Modification Advisory Committee for a safety evaluation. this genetic modification advisory committee that was established under the Ministry of Trade and Industry in 1999 will provide a science-based advice on the outcome of the genetic modification. And it will do that looking at its own guidelines on GMOs of 1999 and on the biosafety guidelines for research on GMOs of 2006, revised in 2013. Will be light touch if the products has been already approved by the same committee. And in the end of the procedure, the Singapore Food Agency will take into account the analysis and the opinion of the committee. And also recently, the SFA implemented a regulatory framework for the use of genome-edited crops for food and animal feed in August of this year. But before the final decision of the SFA, the proposal has to be submitted to the committee, to the GMAC. The GMAC decides whether or not to endorse the application, and then it forwards its decision to the SFA. Currently, a total of 108 genetically engineered crops have been approved for use as food and food ingredients. There are no special barriers for the import of genetically engineered plant products if they are already approved for commercial use in the country of origin and by the SFA. There are no rules on coexistence, and there are no genetically engineered crops approved to date. And at the moment, even if the issue is under consideration, there are no mandatory guidelines on labeling, even if the GMAC is working on that. For animals, that very limited research at the moment. There is no commercial animal biotechnological production, and in any case, the approval process is the same for as well for the plants. So what about finally the relationship between GMOs and patentability? Since the advent of GMOs, basically a race to grab the genetic resources of the planet started, and especially to get patents on them. IP protection is absolutely key as an economic incentive, obviously, for innovation in R&D. But concerns are raised about the multiplication of patents for all the reasons that I briefly pointed out until now. And because basically the patents allow multinational companies control over plant patent genes, for example. With farmers that struggle if they have to buy patented seeds each year, that will affect their income and food security, for the reason that I already mentioned. And in recent years, case law highlighted how this issue is relevant and how multinationals are covered by patent rights. For example, in 2013, Baumann versus Monsanto, U.S. Supreme Court denied farmers the right to sue versus Monsanto, holding that the general principle of patent law, the patent exhaustion, didn't permit a farmer to reproduce patented genetic modified soybean seeds through planting and harvesting without the patent owner's consent. So basically pushing back the general principle of exhaustion of patents that usually provides that once a product is put into commerce, the patent is no more effective. And so it's a huge move in the realm of patents in this sense, and that obviously broadened the scope of protection for GM products. The same approach was taken in 2019 by the Indian Supreme Court, which set aside an order by the Delhi High Court that revoked a patent granted again to Monsanto by the Patent Office on the Bt cotton. And so, as well, at the political level, biotech companies and governments of developed countries tend to press developing countries to strengthen their IPRs, reducing the farmers' income. And businesses in developing countries find a sort of laboratory in which to test controversial biotechnology. And therefore, GMOs is leading to higher costs and lower revenues for small farmers, using basically the less developed countries as sort of labs and land sometimes to exploit for rich multinationals. Finally, this issue of patentability of GMOs is as another chapter with the development of the latest version of GMOs, that is the so-called CRISPR technology. Most recent release of GMO, that's a technology that basically allows to cut in a more precise and effective way the DNA with better and more useful results than in the past, both for plants but also more and more for precision medicine. That's really changing that realm as well. The problem here is that CRISPR techniques are based on a natural process and resemble a lot natural mutations. And so this technology that is more specifically called CRISPR-Cas9 because it's the protein in charge is the protein 9 that's used for this cut of the DNA. And so basically the consequence is that from the positive side, once the DNA is cut with CRISPR, the researchers can use the DNA to repair cells, to add or remove parts in specific parts of the DNA, or even to make changes to the DNA. That's important, obviously, for crops and for agriculture, but is even more important, and indeed it's being breakthrough, definitely, in the realm of health and for human medicine. The level of efficiency, just to give you two numbers, basically is so high that in studies on rice and mustard plants, for example, CRISPR allowed transgenic offspring to preserve most of the modified traits with percentages of up to 89% for mustard plants and 92% for rice. So precise, effective, and long-lasting modifications. The next level of the technology is the so-called gene-right technologies that open even more complex bioethical issues because it can last to subsequent generation, but this may be another lecture. By the way, what I just want to point out here is another case law regarding CRISPR patentability. To conclude, that's a case law that happened in the US and Europe regarding the Broad Institute. The Broad Institute is a very famous institute established by MIT and Harvard University in 2004 to use genomics to improve human health. The institute obtained successfully a patent from the US Patent Office for its use in eukaryotes in 2004. In Europe, instead, in 2020, the European Patent Office revoked the first of several patents obtained by the Broad Institute. Why? Because of the lack of novelty. As I mentioned, the process resembled a lot a natural process, and so the EPO, the European Patent Office, struggled to find a novelty. And also because of numerous prior patent publications describing the same natural process. And so CRISPR is opening another issue for patentability of GMOs, that is how is it possible to foster innovation in CRISPR GMOs through patents, but at the same time respecting the key requirements of patentability. This will be still to be seen, but an element of complexity to which many scholars point the attention are the decision of the U.S. Supreme Court in Mayo, Myriad, etc., that limited the scope of patents. And in that perspective, many scholars are saying that the patentability of CRISPR could soon be questioned in the same perspective of limiting the scope of patentability to provide and to preserve an adequate access to genetic resources for subsequent researchers. It's an ongoing debate. Let's see what will happen, but this is to give you an overview of what's going on. In any case, the more the law creates artificial legal barriers to access to natural products and incentives for the industrialization of agriculture or medicine, that's good because they are improving, but at the same time, the opportunities for local production will be penalized, and again, looking at food, the people can suffer. Happy to answer any questions you may have. Thank you.
Thank you very much, Professor Stazi, for that presentation. A lot of food for thought and excellent PowerPoints. I certainly enjoyed that presentation. So we come to question time, and I have to disclose here that I am not a domain expert. My areas are really tort law and corporate liability. So actually parts of this presentation really did speak to me when you mentioned the multinationals and even supply chain once. That was very connective to my own work, but I'm not the domain expert. What I guess I pick up here are various very large themes involving food safety, rights to nutritional food, the role of the multinationals, and also the efficacy of legislation and regulation. So there's plenty there, I think, to discuss. So what I would like to do is to call for questions from the audience, and the incentive is that I have prepared questions myself, and they get increasingly terrible. So I'd like to ask you first before we have to resort to that tactic.
Hello, I'm Nicola Bianchi, Italian Embassy. So I like a lot your presentation where you, for all the 17 goals of the United Nations plan in the Agenda 2030, you point out the pros and cons. But here we are in Singapore, and you came in Singapore for many years, I guess. And in Singapore, I think Singapore should add an 18 point. That is the 30 by 30 program. So the plan is to increase of more than a factor 3 in few years the local food and the food production. So can you comment how this strong increase in very short time may affect the production with OGM, with genetic modified plants or crops? And on the other hand, there is a risk of softening of regulation since there is this need of very fast change in food production?
Thank you. Great question. I mean, I think that, thanks a lot also for mentioning this plan, this 18 goal for Singapore. I think that goal is for sure ambitious, but fully achievable as far as I see when I come here to Singapore. And I think that until now, it seems that Singapore policy is not pushing hard on GMOs to increase food production. So probably this will not be a focus in that perspective. It doesn't seem that the country is producing and approving so many genetically modified products. My impression is that there is a full awareness of the benefits and the risks. There is a full opening to import of products that can be genetically modified in line with the umbrella of the TRIPS provision that basically says the same, that the country should be open to import of biotech GM products if approved elsewhere. But at the same time, I think that at the moment the use of GM products is not it doesn't seem at least the key instrument to achieve that goal, and probably betting on natural resources that are great here, also with obviously through trade, import, etc. Still seems the key option. At the same time, final remark is that there are two important aspects from the regulatory standpoint. First, the approval process is very precise and detailed, and so there is a clear division of competencies and a clear path to be followed by the two main authorities in charge, so the GMAC and the SFA. And so I think that Singapore is all set if the policy decides to bet on GMOs. And the other remark is that regarding consumer transparency, there is an ongoing work by the GMAC regarding the transparency issue for consumers, the labeling of GM products, and so on and so forth. So at the moment, it seems that the country is ready, regulatory ready, as they say, for further introduction of GM products, and also to provide transparency for consumers.
Thank you. Further questions at this stage from the audience? Sorry that there's no water for you. Cutbacks, you see, cutbacks. Okay. Well, you mentioned regulation, so here you'll see the corporate liability person coming through. I guess there's a question in my mind about models of regulation and what really works. If I think about the sorts of problems that have occupied me in recent times, I guess they involve such things as particularly product liability, and they're sort of generally capable of being dealt with domestically. So the model of regulation that we are told is most effective these days is a decentered type of regulation, okay? Because governments can't keep up, there isn't the funding. So what you do is you decenter the regulation to the level of industry and also to the individual firms. They create the standards, and if the standards aren't complied with, then perhaps enforcement follows. So this is the decentered type of regulation. This doesn't appear to me to be the appropriate model of regulation in this area. It seems to me that what you require is, in fact, genuinely intergovernmental cooperation and also the specification of international standards. Are either of these models of regulation really going to work, or do we have any indication of that?
Yeah, thanks a lot. Great question. First, I do agree on the fact that the center regulation is not going to work in this realm. We have the example that I just mentioned of leaving to the contracts the possibility to set the agreement regarding the exploitation GM benefits, so the benefit sharing from the commercialization of GM products, and it's not working at all because there is such an imbalance of power that the multinationals are able to set the contracts they want and the terms and conditions they want. So the other way around is clearly, the one that can be used, and is being used here, even if the international level is not working properly as well, because of many reasons, mainly because there are quite different approaches, as I tried to point out, among the main economies around the world about GMOs. And the other reason is that the products of this regulatory effort at international level in many years has not been effective as a consequence coming from these international fora. At the national level, it works in the realm of intellectual property, because intellectual property is regulated by the TRIPS agreement. That's part of the WTO, the World Trade Organization, that must be respected by the members at the moment. And so international level is very hard to be as a room for balancing interest. I think that another option that you pointed out in some way is the multi-stakeholder approach, not bottom up, because it's not going to working, but top down, in the sense that the different countries, realistically, has to involve, and are doing that in the best practices at international level, are involving for the regulation the industry, the academia, the bioethics committee, and so on, to get to the best possible regulation, but also decisions in specific patent applications, case law, and so on and so forth. So I think that on such a complex issues that touch upon very different principles and fundamental rights, human rights in particular, and economic interests at stake, the multi-stakeholder approach that involves both public and private actors is the only one probably that can be effective.
Thank you. Thank you very much. There's a question down there.
Professor Stazi, I'd just like to ask this question. In terms of transparency, can this be improved through labeling regulations? Because I understand that different jurisdictions have different requirements. I mean, as an example, which is not particularly relevant here, I understand, for example, in some of the Middle East countries, if you do not have sufficient clarity in the labeling identifying the source of origin, the products cannot be sold. In Singapore, it appears that basically we are wavering between basically not imposing too much of an obligations on vendors labeling their contents, and between our authorities deciding what GMO content products can be brought in. So sometimes you don't know where it falls in the cracks. So my question is, do you think there is a case for stringent labeling so as to improve transparency so that basically FDE can be assured? Thank you.
Thank you. Great question that gives me the opportunity to stress some aspects in which I do believe. What's behind this presentation is my latest book that is exactly on the issue regarding the issue of transparency, traceability, and the possible tools for traceability and transparency. As you mentioned, and as the United States example, along with the approach of Singapore show, I think, is that a model which leaves room to the producers, to the developers, to choose their own solution for transparency, I think is the better in order to balance the economic freedom of the freedom of economic initiative and the requirement of transparency of consumers. There are multiple ways labeling, but the labeling can mean many things, from QR codes to blockchain to whatever can be used. And so it's good that the producers can choose their own tool. And it's part of there are two key aspects here. First, this choice is part, and is more and more important, along with the growth of the awareness of consumers regarding these issues, is part of their relationship of trust with consumers. So the more the tool the producer chooses is effective and appreciated by the consumers, the more the relationship of trust and the appreciation of consumers toward them and their products will grow as well. So it's strictly interrelated, and so I think that's a positive solution. The other comment is some way coming from what you mentioned. I think that the other keyword with trust is education. We, the policymaker, can set any possible solution for transparency, labeling, whatever, all the most recent technologies. But without consumer education and awareness in using that, in using the tools available to get information about what they are buying or eating, all of these are ineffective. So the main tool in using most recent technologies, QR codes and blockchain, is that, especially in older countries, I'm thinking of European countries, consumers are aware of the general debate on GMOs, but are not really still interested and still looking at their mobiles. I love going to the supermarkets to look at people when they buy rice, olive oil, whatever. And there are plenty of QR codes and so on there, but I still don't see people looking for that in choosing the products. So I think that education, and in this perspective, let me say that as all the friends here that I know already know, I think that Singapore is great, not only, especially in the US, but not only as a country. If this education of consumers should be part in all countries of the civic education programs to educate people. Part of the education regarding health should concern these aspects so that they can be aware consumers.
So actually that question related to my second and obviously not so terrible question, which is that, I have a concern with respect to labeling and disclosure, that actually it's a failure to regulate because decisions aren't made by legislators, they're not made by regulators, but actually you've got part of the answer there, which is actually education. So that needs to go along with it. And the good question is, well, how do you do it? And it occurred to me as well when I was reading through these PowerPoints that, this was a strategy which was seen to be the future in financial services law. Okay, the disclosure, the provision of information, and actually in that area, the strategy isn't seen to work very well anymore. Essentially, because what you get is the provision of way too much information, way too detailed information. So actually, the consumer is often no better off. So I guess that another point, and academics can contribute to this, is the question of, well, where is that sweet spot of providing enough information but not going overboard so that it is meaningful? So those are comments. I don't know whether you do want to respond to any of it.
I do agree with you. Financial service, information, privacy are all, not that positive examples of failure of these provisions regarding right to information. So the main question here are, I think, how much information, as you mentioned, and the other is how should this be available? So how should consumers be informed? Regarding how much information, I think that that's why I wrote a book about regulatory technology. I think that technology can be helpful for both the questions. How much information? Current and emerging technologies allow to provide a very basic piece of information when you get in touch with the product, a very short outline of the origin, for example, of a food or a product, and then link or provide a link, provide a QR code, provide a reference to a blockchain approval process, whatever, with further information and further details. Another option are visual charts that in the privacy realm are being explored by some DPAs. That is, for example, the GDPR, provides a long list of information, as you mentioned, to be offered. The same goes for the financial services and so on. That's fine. The data, in that case, the person whose data are used that provides consent should be informed in two ways. One, through an easy chart, visual chart, very easy and very short to read, and the other with a link to detailed information somewhere else. So the list of information provided by the GDPR and the financial service, for example. The other, this is about how much information. Regarding how the information should be provided, the answer is obviously closely related to this. Technology should help to set a two-level approach to this kind of information. One that's acceptable and usable, considering the level of attention and the lack of time that all of us have today. And so very, very short, basic, but important information. And the second, through technology, linking to some more detailed source via internet, via whatever, with all the details, all the value chain, and so on and so forth.
Thank you very much. So we're coming up to time now. I am one of those people who go into the supermarkets and, read the labels, and I thought that's just because I'm a professor of law. And, if that's strange enough, what I realize now is that there are people like you watching people like me in supermarkets reading labels. Now, that's getting a bit freaky. Thank you very much to Professor Stazi. I think this is the point in time when we can show our appreciation once again. And thank you to the audience who make it possible to have events like this. And now I have been pre-programmed to give you some short announcements. So firstly, participants claiming CPD points. Okay, there's a question.
Yeah, hi. Sorry to disrupt. Sorry, I just want to know that you have said GMO food is there and UN has used it to help solve poverty problems. And you have indicated there are a lot of children in many of these countries who have got poverty and they are dying. Can I just know that how is it the main objective of the UN to make sure that the purpose of GMO is to increase food yield so that they can solve this poverty issue? And how successful has it been, especially in third world countries?
Yeah, thank you for your question. It's, this is a difficult question in the sense that, yes, I think that this should be theoretically the main goal for the United Nations. At the moment we are seeing that the other goal should be to end up with wars. But in any case, hunger and malnutrition are absolutely key as issue to be faced. And that's why the food security movement is pushing so hard regarding the use of GMOs. That can be such an important solution in that perspective. And that's why I strongly believe that, especially, the most advanced countries, the most developed countries should help as much as possible to find a balanced solution between food security, and so the need to fight these terrible issues that you just mentioned, and the other interests at stake that are also important for the environment and for local industry and so on and so forth. So I think it's a joint effort of the United Nations, but with all the political problems that they face, given the lack of legitimacy sometimes, the mechanism for votes there and so on and so forth, and national states that should be helpful as much as possible to overcome their own national interests to help provide solution to such severe issues.
Right, so let me get back to that statement. Participants claiming CPD points are asked to sign their names out at the registration desk. Everyone is invited to a fully labelled and full disclosure dinner reception taking place outside. Just snap the QR codes. Thank you very much once again for attending. I really enjoyed it. I hope you did, and I hope the audience did. And finally, thank you very much, and good evening to everyone.